Take a vote on that. Senator Liggins, you got a bill that I think we can get out of here in a hurry. You want to come up first? You have a seat, and we're looking at the bill of Senate Bill 46, LC 363211S, sponsored by Senator Liggins. If you'll raise your right hand, you do solemnly swear that the bill that before this committee is the same bill that we passed out 2 times previously, word for word?
Word for word.
All right. Anybody have any questions of Senator Liggins? Move to pass. I have a motion to pass. That's been seconded. Any discussion on the motion? Back to the main issue. Motion to pass on Senate Bill 46. All in favor signify by saying aye. Aye. Opposed, like sign. Is that quick enough for you?
Mr. Chairman, I think we made history just
I think so.
I don't know where all these bad rumors
But it's abusing people. I've never heard anything.
Thank you.
Who's your sponsor going to be? Senator Liggins, who's your sponsor going to be? Of course. Who else? All right, thank you so much. Rocket Man, yeah. All right, we have next is Senator Stone's not here, so I'm going to get Senator Kirk's bill. Oh, just look who entered. They'll get you right quick. I think we can get yours out. Senator Kirk, I'm going to bring you up at Senate Bill 137. We got 2 from Senator Stone, which we'll get yours pretty quick, too.
Yes, sir. Thank you, Mr.
Senator
Chair.
Kirk, glad to have you with us.
Thank you. Good to be here.
LC 137, I'm sorry, LC 297347.
Yes, sir.
And we're pleased to have you present your bill. Tell us what great harm we're correcting with this bill.
Okay. This was a concern that Senator Jack Hill had. He asked me to carry this bill. In 2005, there was a federal $25 fee that was placed on anyone involved with child support recovery. And at the time, the General Assembly was not aware, at least to Senator Hill's recollection, that there was options as far as collecting it. So they collected $12 from the person receiving child support, and then the person paying child support paid the other $13. This corrects that, puts the total onus of the $25 annual fee of child support recovery on the person paying child support. In committee hearing, Representative Welch didn't like the part where it said and its contractors, the Department of Human Services. I'm sorry. And so on line 24, I'm amenable to strike and its contractors that are. So then the sentence will read, the department authorized to enforce, is within the entity within the department authorized to enforce a duty of support. So we'll make that change on line 24 and the same change on line 43, striking those 4 words, right. 1, 2, 3, 4, 5 words. And I'm amenable to that and would ask for your favorable support.
You know that will now require it to come back to your body for approval.
Yes, sir.
All right. Any questions of the presenter? Senator Kirk. And, you know, what you talked about, we've had discussion on this point before the meeting today, but
yes, sir.
There was, I believe, back when this was passed, it was, we thought, requirement that the money had to be paid by the applicant first to be reimbursed at some point, but that's apparently not the case.
Yes, sir. I mean, there was a crazy system, and we're clearing all that up and make it easier for the department to keep up with as well.
Very good. Thank you.
Thank you.
Is there any questions of the presenter by members of the committee? I don't see any hands. Senator Kirk, is there anyone here from the Department of Human Resources that would like to either say amen or give comment about the bill? Ashley, don't be embarrassed. Great. Okay, we're clear on that then. Thank you. Is there anyone else who wishes to address the committee on Senate Bill 137. If not, we will close off further public comment. The bill is now in the rest of the committee. Do we have a motion?
Move recommendation to pass.
Motion do pass. Is there a second?
Mr. Chairman, I thought we were
Yeah.
you want to do the amendment?
I'm gonna do the amendment after we get the main question before the committee. All right?
Well, I was just saying you could just do pass by
Uh, Just stay with me, will you? Stay with me. I've got a motion to do pass. Do I have a second? There's been a second. Any discussion on the motion? If not, do we have any amendments?
Yes, we have an amendment.
We have proposed amendment. State your amendment.
Thank you, Mr. Chairman. We have, we can do it alternatively. I think the preference was to send things out by substitute. We do have a substitute that strikes the language that Senator Kirk had just discussed before the committee at lines 24 and 43. That substitute is LC 411146S. It's been handed out to you, and you'll note that it strikes the language. If you look at lines 23, 24, it strikes the language that Senator Kirk just.
All right, yeah, so your motion will be really a substitute motion for the House Senate Bill 137 as LC 411146S.
That is correct.
All right, do we have a second to that motion? That motion has been seconded, takes precedent. All in favor of the motion signify by saying aye. Opposed, like sign. That motion carries as a substitute. And is there any amendments to that? Is there any amendments to this bill? No further amendments. The chair will call the main question, which is due pass House Bill 137, LC 411146S. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. I never
Thank-
did get your mic on. I'm sorry.
Thank you, Mr. Chair.
Thank you too.
Committee.
You're
Done.
glad to have you with us. Senator Stone, we have two bills, I think, for you, and we'll start with your Senate Bill 137. Is that the one, right one? No, it's Kirk, I'm sorry.
Okay.
Beg your pardon. I gotta get my file straight here. We'll start with Senate Bill 71.
Thank you, Mr. Chairman. Senate Bill 71 sets out a procedure. I'm sorry, getting my bills mixed up. Senate Bill 71 adopts an amendment to the bankruptcy exemptions, which are a matter of state law because of the right of Georgia to opt out of federal exemptions. What it does is exempt health savings accounts in bankruptcy. This is a policy issue. It is intended to encourage and protect health savings accounts, which are a very vital part of healthcare reform. There was some question that the law already exempted that, but that was cleared. The court said no, the current exemption for health insurance plans did not extend to cover health savings accounts. But as everyone here I'm sure is familiar, health savings accounts are generally coupled by law to high deductible health insurance plans. And there are other restrictions on health savings accounts, what they can be used on. The amount of contribution is limited each year, and there are penalties for using it for a different purpose. So if a bankruptcy trustee liquidates a health savings plan, there's a 20% penalty for the debtor. This would avoid that unfortunate occurrence. We'll be joining several other states in the South that have gone beyond amending their exemptions. Florida, Tennessee, Mississippi, Texas, and Virginia all basically completely exempt them from garnishment altogether, regardless of bankruptcy. So this is an interim measure. I think it have not had any opposition to it so far.
And what you last mentioned, I was going to ask you about this. exemption from garnishment. We did not do that as
Hmm.
an exemption when
No.
we did ours
No.
as far as the,
That,
bill
that's
last year.
that's something for another day.
another day, correct, okay. But this will do it as far as bankruptcy.
That's correct.
Allow the person to maintain that account for
Yes,
his medical needs.
right.
Any questions by members of the panel? Yes, sir.
Those exemptions also include protections for Social Security payments.
Mhm.
There's a list, and
There's
it's a
a-
short list of them, but they're essential
Mm.
to the carrying on, if you will, the individual's.
That's correct. Probably the closest exemption would be for individual retirement accounts.
Any further questions of any member on the committee? If not, we appreciate your bringing this bill to us, and is there anyone in the audience, public, who'd like to make comment on the bill? If not, we will close off further public comment, and the bill is now in the rest of the committee. We have a motion to pass on Senate Bill 71. It's been seconded. Any discussion on the motion? No discussion. Are there any amendments? There being no amendments, we'll call the main question, which is motion to pass Senate Bill 71, LC 297284. All those in favor signify by saying aye. Opposed, like sign. Time. We got a bill passed. We'll go
Thank
to your
you.
next bill, which is Senate Bill 87.
This bill,
Senator
Mr. Chairman, sets out a procedure in state law to carry out what happens in a bankruptcy with respect to a judgment. Bankruptcy have an impact on judgments to the extent they impair exemptions and as to all future property. But of course, a bankruptcy court has no authority to order anything done on a state record. So this simply sets out a procedure, whereas up to this point it had been done on an ad hoc basis with opinion letters from attorneys, with filing and cross-indexing discharge orders and lien avoidance orders. But that really does not provide the level of certainty that closing attorneys need when handling matters after a bankruptcy is completed. So what it does to carry this out is allows a petition to be filed in the court where the judgment was entered, served upon the judgment creditor, and attached to that petition would be a certified copy of either the discharge or the order of confirmation, which has the impact of restoring property free and clear of liens other than those retained in the debtor's plan. Along with that, the schedules that itemize the property would be filed with the petition. It simplifies and clarifies and sets out a procedure that didn't exist in the past but needs to be in our code.
So take me through the steps. You'd have the certified copy, you file your petition. With your petition, you have the schedule showing that particular debt as being a discharged debt.
Discharge debt.
Is
that's
the
right.
clerk then authorized or directed by the Superior Court to so enter that discharge
Authorized
on
would
the
be,
judgment?
authorized would be the operative language, and I think that's on line 30 and 31.
Okay. Very good. Mhm. Do we have any questions from members of the committee? There being none, I think we've got one person who's listed, Mr. Daniel Welch, who would like to speak to the committee. Come up, Mr. Welch. And this
You
is
want me
Bill
to
Hou-
stay here, or?
Please, you can stay there. Mr. Welch, you can sit if you like next to Senator Stone,
I have to recuse myself as my cousin.
your cousin. Is it Welch? Oh, no, I'm sorry, I said Welch. It's Melchi, is it? I'm sorry. M-E-L-C-H. See, I'm so used to saying Welch all these years. Melchi, I beg your pardon, sir.
Yes.
Melchi,
Yes, sir.
pardon me.
Um,
Give us your name and by who you're representing.
Sure. My name is Daniel Malkai. I'm an attorney and partner with Luder, Larkin and Hunter. We are a law firm in Alpharetta, Georgia. We have satellite offices around the metro area. I actually live in this Vasquez district.
Okay.
Noticed you there. We represent approximately 1,000. My firm represents approximately 1,200 community associations. That could be anything from a homeowners association
Right.
to a property owners association, condominium, anything like that. The only concern that we have with this bill, that when we looked at this, was on lines 26, lines 25, 26. It's very broad language. It states that the court will enter an order canceling and discharging the judgment as to the property and any other property acquired. The problem that we have with the language as written is that it is so broad. Oftentimes, I will give you an example of a lawsuit filed by homeowners association. Count 1 would be seeking money damages for unpaid assessments that they owe. Count 2 would be an order seeking that they stop renting their property in violation of the covenants, or that they repaint their home they painted their house purple or something. It's in violation of the covenants, and that's part of the judgment. Unfortunately, what this says right here, the exact language is going to be interpreted by a Superior Court judge as satisfying and canceling the judgment. I understand the intent behind it. The intent behind it is to cancel the money damages portion of the judgment. And I believe that could be clarified. The problem is the way that it's written right now, the Superior Court judges will be forced to cancel the judgment, because that's what it says. And it says as to the property. And while the rest of the bill, while the rest of the language of the of the bill discusses the purpose behind it, the operative language that tells the judge what they need to do says that they cancel the entire judgment. Not all judgments are just money damages. Some judgments have other relief, like paint your house back to what it's supposed to be, get the pink flamingos out of the front yard, things like that. That's kind of what we're concerned with. I don't know anything about striking up legislation. or
Okay.
making it. What I can do is I've
Let me
kind
ask
of
this. Have you
suggested-
spoken to Senator Stone prior to today about
We have
this
not.
matter?
We just learned about this bill just very, very recently, and we were not aware that it had been assigned to this committee until about 3 hours ago. They called me up and said, "Can you get down there?" And I said, "Yes."
Okay.
We actually had some slight language in here just to make it a little bit more clear, so that we wouldn't run into these problems.
Well, we're going to have some questions, I believe, from members of the panel committee. Mr. Welch.
Thank you, Mr. Chairman. Does the gentleman look at line, if you would, look at line 25. There it's talking about payment of a judgment, referring to, in my mind, a monetary amount that the judgment is required. And that's the judgment that is seeking relief. Does that not clarify, does that language as it exists in the bill, does that not clarify the kind of judgment? And then if you look back at line 27, it says discharging such judgment. So it's referring to the payment, a judgment payment that's owed in the preceding clause. So that's why I'm not sure that I see necessarily a problem. Now, Senator Stone may want to add clarifying language, and it's his bill to recommend that, but I wanted to raise that with you.
We read that, and we thought, if this were to pass in this current form, would we be able to argue that in front of the court? And I looked at that exact language. All of that is very specific, and it does talk about the judgment lien, and it does talk about the judgment lien throughout the top. However, at the bottom, it just talks about the judgment. And if they strike the entire judgment, which I'm concerned that the court will say, it says right there, the court shall enter an order canceling and discharging such judgment as to the property. It doesn't say as to the judgment lien or to the extent that the relief in the judgment has been discharged in bankruptcy. If that sentence were added there, it would clear up any problems that they had, and
What you're looking at, maybe the payment obligation of such judgment?
that's kind of what I suggested
Okay.
on there.
Let me hear from Mr. Stone, Senator Stone, excuse me. What were your thoughts on this?
Well,
Secretary?
my thoughts are that the limitation language that follows canceling and discharging such judgment as to such property, which is the exempt property that is filed with the schedules, and as to other property acquired after the filing of the petition, that basically is a restatement of 11 U.S.C. Section 552, which limits the post-petition operation of a lien. That I think would make it clear that we're only talking about a lien on certain property, and not an obligation for executory, so to speak, going forward, like an injunction or something that has ongoing duties. It's a liquidated amount, and it's in the context of a judgment that has been obtained by a plaintiff, so it doesn't impact on any other liens that are.
Any other questions, any other questions of Senator Stone about the point from anyone on the committee? Mr. Melkai.
Yes, sir. Another situation that arises oftentimes is that there will be a judicial order to allow a homeowners association or property owners association or condominium association to foreclose its to foreclose its statutory lien on the property. That could be located in a judgment. This just talks about
Well, statutory lien being what?
a statutory lien for assessments.
Financial amount.
Those survive bankruptcy discharges and can be foreclosed regardless of whether or not they were exempted in
Well,
bankruptcy.
All right. Go back, what we said earlier, it's got to be listed on the schedule as being a discharged item. So if it's not listed on the schedule, it would not be a discharged item.
If
Correct?
they list that would be correct.
Yes,
But
sir.
if they list the property, a Superior Court judge is going to look at that, and they're going to strike the entire judgment, the entire underlying judgment, which could include an HOA's right to foreclose its statutory lien. We would just urge that what we're urging is that the language, following language, to the extent that such relief and such judgment has been discharged in bankruptcy, be added to line 26.
Well, what I had in mind, as I mentioned earlier, just as a discussion for you, Senator, is on line 25, discharge from the payment obligation of such judgment. If the word obligation were inserted there, would that be
Yes.
something that might clarify this point raised by the gentleman?
I would think that would add clarification.
All right, so that you know there could be more than just obligation financially in a judgment. The other things would still stand as far as direction, what's to be done or not done.
Mr. Chairman, I believe that language is actually better than the language that I just thought of, so
Okay.
I think
Now,
that would
where-
actually clarify it.
Mr. Chairman, what was that last language?
I was on line 25, after the word payment, insert obligation.
All right.
So it's read, that the bankrupt or debtor has been discharged from the payment obligation of such judgment, or of the debt upon which it was recovered, and the property subject to the judgment lien was exempted thereunder.
Yes. I think that insertion of obligation clarifies it, and the remainder of the sentence. I will say this, you are in a bankruptcy required to list your exemptions,
Yes, sir.
list your creditors, and the creditors have a time period to make an objection to those exemptions, and
Right. And
and
well, you'd have the case of what he's talking about. They would come into bankruptcy court and say, wait a minute, Judge, yes, this part of the debt is discharged, but this other one is not.
Right.
And so the order would be crafted by their making their appearance.
in
Make sure
this
that's
proceeding,
recognized.
and also in this proceeding here because they have to be served with the
That's
petition.
true.
And they'd have an opportunity to raise it twice, actually.
Right. All right.
Thank you.
Thank you, sir. Do we have anyone else who wishes to address the committee on Senate Bill 87? If not, we'll close off any further public comments. Sir, do you have any closing comments you
I
wish to
don't.
make?
I think we've covered it
All right.
adequately.
We will take up House Senate Bill 87. The chair will entertain motion. Motion is due pass. It's been seconded. Do we have discussion on the motion? No discussion. Do we have amendments? Ms. Welch, you want to offer that amendment?
Yes, sir. In line 25, Mr. Chairman, after the word payment, insert the word obligation. So
All right.
between payment and of, the word will be obligation.
Do we have a second to the Welch amendment? It's been seconded. Do we have any discussion on the amendment? We'll first have a call a vote on the amendment. All in favor of the Welch amendment signify by saying aye. Opposed, like sign. That motion carries. We're back to the main question. Are there any further amendments? Chair will call the main question, which is due pass House Bill 87, LC 297285 ER as a committee substitute. All in favor signify by saying aye. Opposed, like sign. Motion carries. Thank you, Senator Stone. Glad to have you
Thank
visit
you,
with
Mr.
us.
Chairman. Always a
We'll be
pleasure.
visiting you, I'm sure.
Look forward to seeing you.
And you know, we've completed our work in 27 minutes. We had Judge Hightower, Dusty Hightower with us today, which we're always pleased to see you here. I think Judge Hamrick was supposed to be here, but he didn't.
He got pulled to a different meeting.
He got it in a different meeting. We're glad to see you and appreciate you dropping by to be with us today.
Thank you, Mr. Chairman.
Thank you, Senator.
Thank you.
We will stand adjourned.